Sotomayor, you've told us that you will follow the law and follow precedent, and you've made a very big point of this, and that's all well and good. But some of the court's most important landmark rulings overruled long-standing precedent, like Brown versus Board of Education, which ended legal segregation. Now, as an appellate judge, as we know, you're required to always follow precedent, but as a Supreme Court justice, you will have the freedom to depart from precedent. So tell us how you will decide when it is appropriate to alter, amend, or even overrule precedent.
The doctrine of stare decisis is a doctrine that looks to the value in the stability, consistency, predictability of precedent. And it starts from the principles that precedent are important values to the society because it helps those goals. It also guides judges in recognizing that those who have come before them, the judges who have looked at these issues, have applied careful thought to the question and viewed things in a certain way, and a judge should exercise some humility and caution in disregarding the thoughts and conclusions of others who came in that position before them. But that's not to suggest that the doctrine says that precedence is immutable. And in fact, I believe that England had an experiment with that question, and it was not horribly successful. Precedents are precedents. They're not immutable. They have to change in certain circumstances. And those circumstances generally, as have been described by Justice Souter in the Casey case, are probably the best articulation people have come to in sort of talking about the factors that courts think about. And it starts with how much reliance has the society put into the precedent? What are the costs of changing it? I shouldn't say start. He put them in a different order. There's no real importance to the order because all are factors that you put into the weighing as a judge looks at an existing precedent. It looks to whether whatever the court has said, is it providing enough guidance to the courts below and for people to determine what they can or can't do? Is the precedent administratively workable? Number 3, and as I said, there's no ordering to this, are the facts that the court assumed in its older precedents, have those changed so that it would raise a question about the court revisiting a precedent? Also, there are developments in related fields to precedents and approaches that are developed in those cases that may bring into question the foundation of an older precedent. Brown versus Board of Education has often been described as a radical change by some, and the public perceives it as a radical change. When you actually look at its history, you realize that there had been jurisprudence for over 20 years by the court striking down certain schemes that provided separate but equal, but in fact didn't achieve their stated goal. And so there was underpinnings in Brown versus Board of Education that in those precedents that came before Brown that obviously gave the court some cause, some reason to rethink this issue of separate but equal. They also had before them probably one of the most famous dissents in American history, which was the dissent by Justice Harlan in Plessy. And Justice Harlan so carefully laid out what the Constitution said, what the principles of the Constitution were that motivated the Congress to pass those amendments. He laid out the court's precedents in that area, and he said separate but equal is just not consistent with the Constitution. Now, this is in an opinion where he described another group of people as different. And so it wasn't that he was being motivated by his personal views. He was being motivated by a view of the law that the court in Brown made a change about. One final factor the court obviously looks at is the number of times a precedent has been reaffirmed by the court. But all of these things are decided on the basis of judgment of a particular case and the arguments that are raised before a judge, and recognizing as a judge that precedent is deserving of deference. Precedent and changing it should be done cautiously by a court, but precedent can't stand if other things counsel that it not.
Good. Judge, I'd like to return